what do you think the best tips are for patent owners for motion to amend practice?
Yeah, so I can jump on that. My number one tip for patent owners tends to be don't. I think those of you who saw my LinkedIn post yesterday got kind of a flavor of this, but you have a lot of better options and a lot of faster options and a lot of options that don't involve some pesky petitioners counsel raising 101 and 112 and all kinds of other grounds against you. That can include reissue, that can include re-exam, that can include, if you've got a continuation, filing it with a track 1 request. And often, especially with a track 1 request where, you're likely to get a final disposition within about a year of filing, well, that's going to be faster than litigating a motion to amend and then going to the federal circuit. With so many other options available to you that are often faster, that often involve that often have more limited participation, if any participation, available to a patent challenger, very often you've got better options. You've also got to think about just sort of the overall business case, right? Like, am I okay with what, my damages case looks like after intervening rights kick in? On the other hand, how much patent term is left in my patent? On the other hand, like, do I need to keep at least one claim of this patent alive, regardless of what it says, because I've got some kind of royalty-bearing agreement as a licensor that says, well, as long as one claim is active, doesn't matter what the claim actually is, I get royalties off this. I can tell you, I've done 60-something IPRs, patent owner side. I have never once filed a motion to amend. I've never once seriously considered filing a motion to amend, just based on a lot of all of this stuff. So think about your other options. But if you're going to do it, think carefully about the business case, proofread your claims very, very carefully, because the board is not going to fix informalities for you, and paper up the new matter issue as best you can, because if you lose that issue at the board, you're probably losing it at the federal circuit because of the substantial evidence standard.
And just to follow up on what Kevin said, with the proofreading, I have seen, proposed substitute claims that have had issues with them that have been part of the reason, the board has rejected them under 112. So especially when you have really long claims, which is in some of these cases, you need to have a couple people in there reading through the claims and going back and forth with the patent to make sure that you're not creating any issues. Another big thing that I've seen is, now that the board is giving preliminary guidance, the patent owners need to read that guidance really carefully. I've seen instances where the board has raised an issue in the preliminary guidance and the patent owner just didn't address it in their revised motion to amend. In one case, the board had a footnote that there was a 112 issue in certain one of the dependent claims. And it would have been, an easy fix, but they filed a revised motion to amend and didn't address it. So patent owners really need to carefully review that guidance that you're getting, so that you can be in the best position.